Hello everyone, thank you for joining me today. My name's Louise and I am actually a graduate in law, so I thought it would be great to do a lesson for you guys for an introduction to the English legal system. So this should be really good if you're interested in maybe studying law or just for anyone really. It's really good to know how these things work in the country that you live in. So we're just going to see kind of the structure of the legal system and how our laws are made. The first thing I want to say, if you can see this kind of hammer looking thing and the big cross over it, these are called gavels, and often in movies or on the TV, this is what we see judges banging these and saying kind of order, order. We do not have these in the English legal system. It's a myth. If you've seen it in a TV about the English legal system, it's not factually correct, or maybe it's the American system that we're seeing. So first thing, no gavels. The second thing is the English legal system covers the law of England and Wales. Scotland and Ireland actually have their own slightly different legal systems. There is sometimes some overlap with them, but generally when we talk about the English legal system, it's just the system for England and Wales. So, first question to ask ourselves is, what is the law? And there's really no single, complete, exhaustive definition of the law, but lots of definitions will include similar elements. So if we want to try and put some kind of definition on it, it's a set of compulsory rules about human behaviour created and enforced by the state. So that might sound a little bit complicated, but basically we can't just say that the law tells us what to do or the law is about crime, because the law covers loads of different things other than crime. It covers the house you live in, what taxes you pay, who's allowed to come in and out of the country. So it's really not just about someone stealing your bag in the street and then what happens. It's a lot deeper than that. So just to say that the state is defined as the territory, so the area of land, covered by a system of government. So every kind of country has their own government. We can think for our purposes really as the state being a country. And the state with a capital S are the people who are running that country, so the government. Okay? So basically, they're the rules made by the state, made by our government, that we have to follow. And they're enforced by the state. That means it's the state who comes and checks that we're following these rules. And if we're not, it's the state who will punish us or tell us how we should get our remedy, our kind of reward if someone has broken the law against us. The next question to ask is, why do we need the law? And I think you can already have some kind of general idea of this, but to give you some pointers, it provides minimum standards of acceptable behaviour. So that means we all have to be at least this well behaved. Some people are kind of this well behaved, some people are just a little bit above the law, but we all have to be at least this well behaved, or if not, we get punished. It also provides a method of obtaining justice and resolving disputes. So justice is kind of a sense of what we think is fair. If someone takes my bag in the street, we will generally think, oh, well, that's not fair. And that's our sense of justice, of things being fair. It also promotes order in society. So if we didn't have the law, things would all be a bit crazy. Who would stop that man coming and taking my bag in the street? We need laws to stop that kind of thing. And just to point out, this picture here is of Lady Justice. She's normally shown with her scales of justice, and she's normally pictured blind as well, with a blindfold. And that is because there is a phrase that we think that justice should be blind, as in it's judging the case without looking at the people. So it doesn't matter if you're a woman, it doesn't matter if you're a child, if you're tall, if you're short, or whatever other characteristic. That shouldn't be what's important. What should be important is just what has happened. Okay, so we have some different types of law. We need to begin to understand these distinctions. The first important one is between public and private law. So public law is between the state, so that's like our government, and individuals, so me and you. And it's how the law regulates interactions between the state and its individuals. These laws can be about a number of different things. So they're about how we create laws, so that's constitutional law, So there are laws about how laws are made. Don't worry too much. So that's constitutional law. There's also laws about how the government departments themselves are working, and that's called administrative law. So if the Prime Minister, for example, or a government department does something wrong when they're in office, when they have their job, there is this law to punish them as well. So even though they make the laws, there are laws to stop them from doing things wrong as well. We also obviously have criminal law, and this is in the public law sphere. It's about when an individual does something wrong, it's the state, the government who tells them, you did that wrong, and we're going to punish you for it. And then we also have human rights in the public sphere. So the other type of law in this public-private distinction is obviously private law, and this is about individuals interacting with each other. So it's not me versus the government, it's me versus you, or me versus random man on the street. Yeah, it's about individuals in specific situations. For example, in business law, so between two different businesses. In family law, so if there's a fallout between parents, for example, if parents want to separate, then we look at family law, and that is private. The state doesn't really have anything to do with that. And then also in what we call civil wrongs, such as negligence. So that is, for example, if I accidentally run you over with my car and I break your leg, I then might have to pay for your hospital costs, for the cost of you not being able to go to work, for the cost of you having to pay for a taxi to take your children to school, just because if I ran you over and I was being silly and not concentrating and driving dangerously. That's between me and you. That's not the state saying, oh, Louise, you did that wrong, so we're going to punish you in a criminal way. That's private law there. Okay? And that example also helpfully brings us to our second distinction. They kind of overlap. They're two different ways of splitting up the law. So don't worry if you think, oh, well, I don't really understand because civil is also private. That is kind of how it works. So the next distinction is criminal versus civil law. So criminal law obviously comes into play when you commit a crime. And just to think about, well, what is a crime? A crime is when you've done something against a rule which the state, so the government, considers to be so important that it's considered to be an act against the state as a whole. So I've not just accidentally scratched your car when I was driving, a little bit stupidly. That's not important enough for me to go to prison for. The state doesn't consider that to be, that's kind of like, you guys sort that argument out between yourselves. The state, we, the government, don't think that is so important that you should be punished by us. It would more be if I was driving and I was drunk and I hit you and then I do some serious damage to you. I've been bad enough there that it's a rule which breaks a rule that the state has made, so I need to be punished for that. Okay, and the state will enforce this through institutions like the police, the courts, the prison service. So this is all about bringing that person who's done something wrong before a criminal court, and then they can be held responsible for their crime. So when you commit a crime against someone, if you, for example, steal my handbag, the criminal case against you is not being brought by me. It's not me, Louise, saying, you stole my handbag, I think you're a criminal. It's being brought by the state, and we see this when we see the way that you would write the name of a case. So we got here, so my surname is Marzano. So if I was the one who stole the bag, I'm being taken to court by the state. They would write my case as R.V. Marzano. And the R here it's Latin, it stands for Regina, which means the Queen. When we have a king, it will be Rex, it will still be R, but it's the Latin word for king or queen. So it's basically the claim against me saying, Louise, you're a criminal and we need to maybe punish you, is coming in the name of the Queen. It's in the name of the state, okay? Even though, obviously, I haven't actually done anything wrong to the Queen, I haven't stolen the Queen's handbag, but it's an important enough thing that the state will bring it on my victim's behalf, okay? The next area is civil law, and it's basically, we're talking about the private law realm here. It's the same kind of thing. It's when you do something wrong and you have a claim against you by an individual, and that person is called the claimant. The person making the claim is the claimant. So in this instant where I've stolen someone's handbag and I've got a criminal case against me, I also might have a civil case against me. If you had loads of important stuff in that handbag and you want to sue me, you can make a claim against me in the civil courts to say, Louise, you stole all of my stuff, I need that money back. Okay? That kind of thing. Or like we spoke about earlier, me running you over, breaking your leg, I need to pay for your hospital costs, for your taxis, all that kind of thing. Right, hope you're still with me. We're going to have a look at the different types of courts. So, I know it looks a little bit confusing, but don't worry, we're going to go through it step by step. So first of all, we can see the division between criminal and civil law that we've just spoken about. So criminal being the state is bringing that case because I've done something so wrong. And the civil one being you're bringing a claim against me for some money because I've done something which has affected you. Okay? So let's go down the criminal law leg. So if you do something a little bit wrong, maybe you've stolen something small, you will start off in the magistrate's court. So it's a fairly low level crime. If you do something really serious, you don't go to the magistrate's court. If you murder someone, for example, you're going straight into the Crown Court. So it's really just for what we call petty crime, for lower levels of crime. And here you have someone called a magistrate deciding your case. They're fully trained, but they are all volunteers, so the magistrate system is mostly voluntary. Then we have the Crown Court, so as I said, that's for our more serious crimes. And here we have a judge and a jury. So the judge guides the case and they explain to the jury what they have to do, they lay out the law, but ultimately it's the jury who will decide if they think you're guilty or innocent. And the jury, if you didn't know already, are 12 randomly selected people from the general public. So anyone, with a few exceptions, in the UK can be put forward for what we call jury service. And you go and sit and you listen to all the case, and at the end you have to decide if you think that person is guilty or innocent. It's one of the hallmarks, one of the kind of most important things about the British justice system, and it has been adopted around the world in many different jurisdictions as well. So it's really kind of representative of the British justice system. Bringing ourselves over to the civil law side, we have the county courts and the high courts of justice. It's basically the same kind of structure. The more lower level cases in civil courts go to the county courts, the more serious cases will go straight to the High Court of Justice, and so the same kind of structure on both sides. So these four courts that we've seen, these four lowest courts, are all called courts of first instance. It's the first place that your case will be heard. We then, moving up, have the appeal courts. So these here are appeals against the decision made in the original trial. An appeal is basically you saying, well, I think that they didn't decide that correctly in my first case. I want someone to have a look at that again for me. Okay, so we start in the Court of Appeal and then we go up to the highest level. This is the highest level in the whole English legal system, is the Supreme Court. And in case you already know a little bit about the law, this used to be called the House of Lords. Okay, but it got changed in 2009 to be called the Supreme Court, but it's basically the same thing. And at this stage, you can only decide appeals on points of law. So what that means is, the first instance court decides the facts. They decide, Louise, you were over the limit of alcohol, you had drunk too much alcohol, and you were driving at 45 miles per hour in a 30 mile per hour zone. They are facts. You can't go to the Supreme Court then, I can't go and say, oh, actually I hadn't drunk that much and I was only driving at 32 miles an hour. The Supreme Court will say, we don't care what you want to say about the facts now, that's been decided. The only thing that you can bring an appeal to the Supreme Court for is the law. So you can say, actually, in the Crown Court, they got the law wrong. I agree with what they said about the facts, but they said that the law is that you can only drink this amount of alcohol. But actually, I think that the law is you can only drink this amount of alcohol. Okay? The alcohol example isn't something that you could actually bring to the Supreme Court because that is laid out very clearly in the law. It's things which aren't necessarily as clear, and we're going to come to that a little bit later. Another thing to note is that the courts have a hierarchy. So that means anything that a higher court says, the lower courts then have to follow. So if the Supreme Court decides that the law is X, the Court of Appeal or the Crown Court or the Magistrates Court can't later say, oh, well, I think it's Y. The Supreme Court is like the boss of all the courts. Anything that they say, everyone else has to follow. But the same further down. So the Court of Appeal can say something and then the lower courts have to follow that as well. Okay? So we do also have influences from other courts as well. So this is a slightly more complex diagram of this. It's pretty much the same thing. I just put it on because I want you to look at these, the European Court of Justice and the European Court of Human Rights. So the European Court of Justice is to do with the European Union, and it deals with action between the European Union, the EU, if you've heard of that, and its member states. So we used to be a member state of the EU. We now no longer are, but this court still exists for the EU and the states which are still a part of it. So the situation here is now really complicated post-Brexit. Don't worry too much, but basically we no longer have to listen to future decisions of this court. Any law which has already been made in the past and that is in our law we keep, but future decisions we don't necessarily have to listen to. The European Court of Human Rights, we are still a part of post-Brexit. That's a different thing. It's about the Human Rights Act 1998, which we have put into law. That's our version of the European Convention on Human Rights. It's basically Europe got together at one point and decided they wanted to set some basic rules on human rights and we all have to follow them. And it's this court at a European level which decides if there has been something against those human rights. Okay, we have a number of different sources of law. A source is where something comes from. So if you were to ask me, Louise, what's the law on drunk driving? I would have to think about where do I go to explain that law to you? And we have these three different main sources. So the first one is legislation, that's acts of parliament. So that's the government and Parliament making laws. We also have case law, also known as the common law, and we have European Union law. We're just going to explain all of those in a little bit more detail. So, as I said, legislation is the law kind of made by Parliament. It's the highest, the most supreme form of law in England and Wales. So any other law, whether that's case law, has to agree with this. So this is like the boss of all the laws, just like the Supreme Court is the boss of all the courts. When the law is being passed by Parliament, it's known as a bill, and when the bill is passed, it's known as an Act of Parliament or a statute. Okay, and there's different types of bills which are passed by Parliament. We're most concerned really with public bills, and there's two types of these. There's bills sponsored by the government, so that's whoever's in government at the moment can bring a bill into the parliamentary system to be debated, and you can also have private member bills. So that's any one of these people you see on the screen here who are in the House of Parliament can say, I want to bring this bill for discussion. So how is legislation passed? So every Act of Parliament has to follow a set procedure through both Houses of Parliament and beyond that. And if it's not followed, it can't become law. So we have to go through this. So we start with the ideas and discussion stage. So lots of sources for where these ideas come from. As we said, come from private member bills, from government bills, from petitions. So if you see someone looking for a number of signatures on a petition, if you get a certain number of signatures, it has to be discussed at some point in Parliament. It's then put forward as an official paper, if either a green or a white paper if you've heard of those, and then it's discussed more. And then it's read a number of times, so 3 times, in the House of Commons. This is where, if you've seen any videos of any debates in Parliament before, where all our politicians, like Boris Johnson at the moment, the Prime Minister, sit and they debate all of these different ideas. If it's passed in the House of Commons, if they say, yes, we think this should be a law, then it goes to the House of Lords. That's another place where a different set of people sit and they also decide whether they think it should become law. If it passes both of these, it then still needs to have royal assent. So that's the King or the Queen saying, okay, yes, I also agree that this should be a law. So it has to follow these 3 steps. The House of Commons, the House of Lords, royal assent. This last one used to be way more important than it is now, when we had kings or queens who kind of were the ones making all the big decisions in the country. Now it's really just a formality. It hasn't been refused since 1707. You're not going to get a bill going to the Queen and her now saying, no, I won't sign that. She will always just sign it and it will go into law. Because we are now a democracy, the power is in these voted in politicians, not really with the King or the Queen. Okay, so that's our first source of law. Our next source of law is the case law, also known as common law. These people here are the people in the Supreme Court, that boss of all the courts, and they are judges. And case law comes from the judges. So the judges have a number of roles to play in creating and developing the law. So first of all, it's important where Parliament hasn't legislated at all. So if there's none of those acts of Parliament, none of those laws made by the government that have come through, we have to look to the case law. So we look to what judges have said in previous cases. That's the first place it's important. It's also important even where Parliament has passed laws, because sometimes we need someone to interpret the law and tell us, what does it mean? If, for example, a law passed by Parliament says vehicle, we have to think, well, what does that word vehicle mean? Obviously, we assume it means cars. But does it mean skateboards? Does it mean electric scooters? Does it mean me running? Am I a vehicle? What about a tractor? What about a lawnmower? So it's all these things where at first the word vehicle seems simple and easy to understand, but actually it's really not. And you might get cases which come up which make you think, oh, well, I don't know if a skateboard is a vehicle or not. And then we can look to case law, we can look to what the judges have decided before to help us understand if a skateboard would be a vehicle or not. And this brings us to something called the doctrine of precedent. And this is the most important thing to know about case law. It's basically saying that each case ever decided in England and Wales by our judges lays down a rule of law which must be followed in later cases. So if there was a case in 2001 which said, yes, a skateboard, for the purposes of this law, is a vehicle, I can't then decide a new case in 2021 which says, no, a skateboard isn't a vehicle. You have to follow what the previous case has said, unless you can argue some reason why that case was so different to today that it shouldn't be classed as a vehicle. For example, if you could say, well, that one before was an electric skateboard, so that is a vehicle. But mine today, in this 2020 case, is not electric, so I'm not going to say it's a vehicle. So you can find a reason to say, well, I'm not going to follow that previous case. But generally the rule is you have to follow the cases that have been decided before. Okay? Remember also the hierarchy of the courts that we spoke about. So if there was a previous case decided by the Supreme Court which said skateboard, yes, that's a vehicle. The Court of Appeal cannot come along and say skateboard, no, that's not a vehicle. They have to follow what the courts above them say. This sometimes can be straightforward, but what's really complicated is these judges will write a really long judgment, sometimes like up to 100 pages on one case, and it's only the very bit that decides the case which is the law. So basically, the lady in the middle, Lady Hale, she's the former president of the Supreme Court, she might have written a 100-page judgment on this case, and the only bit that was law is that the skateboard is a vehicle. She might have also spoken about bicycles, about electric scooters, about cars, about horses, but that's not law if that's not what the case actually decides. So we have to be really careful when we're reading judgments about what actually decided the case and what didn't, because it's only the very important bit which decided the case which we need to follow later. The other source of law which I mentioned is European Union law. So in the past, this was the highest ranking form of law in the UK. It would take precedence over all the others, as in it was the boss of all the laws. And this was one of the things that was really controversial. It was a factor in Brexit. So post-Brexit, European Union law is not an official source of law anymore. It no longer binds the UK, so we can decide something different to EU law. But In reality, we did convert a lot of EU law into our own law now. So when we left officially on December 31st, 2020, we converted a lot of what the EU law says into our own law. So although it strictly doesn't bind us, it is now in our national law, and we will be spending the next few decades unpicking it and choosing which parts we actually want to keep going forwards. So just to finish off, I want to talk about, is judge-made law, case law, a good thing? Because it's one of the things which is often really controversial about the British legal system. It definitely has positives and negatives. So in terms of advantages, it does create consistency because it allows because of the hierarchy system and the doctrine of precedent that I spoke about. So the fact that lower level judges have to follow what higher level judges, and future judges have to follow what past judges said. So that makes consistency. All the judges have to be kind of following each other. They can't just go off and say their own thing generally. It also allows flexibility. So, for example, if we had a case 20 years ago which said, no, skateboards are not vehicles, okay, we have to follow that. But then we get electric skateboards developed, and now it seems more like a vehicle. Sometimes we would have to wait ages for legislation to be passed about that, and that can take a really long time. Or if we get a case through the courts, the judges can say, well, actually, we can see now that skateboards have developed and now they're electric and they can go really fast, so yes, we will say that it's a vehicle. Okay, so it allows us to be flexible. Similarly, it's based on actual events, so it's practical. So we're not just thinking of law in the abstract. In a case, we have actual hard facts before us, so that can help to make laws which are just. Disadvantages are that it can be difficult to understand and apply, so you can't just open your book where all the laws are, read what it says, this is the law, and you're done. You sometimes have to go to cases from 200 years ago, and then you have to find a case from 50 years later, and then you have to decide, oh, well, which one actually tells me what the law is? It can be really difficult, and this as well can create confusion and discrepancies, so differences. The last thing to say is that the system is reactive rather than proactive. What that means is, if I want to know, well, I want to take my skateboard through this park, but it says no vehicles are allowed, how do I know if my skateboard's a vehicle or not? I can't just go and ask the judges. We have to wait until a case comes before the judges. So they can't decide anything until they have that case before them, which they can react to. Okay, so this is sometimes a problem on some really contentious, on some really kind of difficult points of law. We're sometimes just waiting for the right set of facts to come up to go before the judges so that they can decide it. Okay, so this was quite high levels today, so anyone watching, I hope you've been able to take something away from this. I think the most important thing is probably the structure of the courts. That's a really good thing to know about. So thank you very much for listening. Hope you've enjoyed, and that I will see you next time. Thank you, bye.